This is the time set for
Trina Kay, on behalf of the state, for the record, the next of kin are present in person as well as virtually, and the victim in the 2022 was also present in person.
Good morning, Judge Gerald Bradley, Jeremy Caulfield, Danae Suki for Lori. She has waived her appearance.
All right, the court has waived her appearance for this hearing and her request. Mr. Bradley, I received a motion to continue the trial. You're requesting a date of 6 months out, a little more than 6 months out, in February of 2025. Last time we were here, you said you had about a terabyte, I think, of discovery is what you said. Where are you in that process? I assume that's why you're asking for the...
Correct, Judge. I don't remember the exact byte amount, but I did mention 100,000 plus pages. It's now over 100,000 officially because there's been some new disclosures. I've been going through discovery at a much faster rate, but I'm still nowhere near being done. I would note, since we filed the motion, Judge, the state has disclosed on one day another 1,160 pages to extra witnesses, and then a couple days ago, it might have been yesterday, another approximately 200 pages of discovery. It's not like I was ready to go to trial next week, so it's not the end of the world, but if there's ongoing disclosures, that might make February a little bit more difficult if they continue to be larger. Anyways, Judge, I'll rest on my motion. Might you have further questions?
Well, I assume what I'm trying to flesh out is the reason you're asking for the continuance is in order to be adequately prepared for trial, you need time to get through all that discovery.
That's exactly right, and that's what's in the motion, Judge. I'm just nowhere near getting through and since April 100,000 pages and all the other items I've listed toward.
All right, does the state have a a position on the motion?
Your Honor, the state is aware that we have disclosed over 101,000 bait stamped pages, as well as a significant amount of digital media. All in all, it's more than 15 terabytes of data. We have disclosed additional discovery, which were mostly lab notes, as well as some Rule 15 issues with one of the lab members. We have one additional thing we're waiting for. We did provide one of the testimonial agreements used by Idaho. They sent us another one, but it was not legible, so we're trying to get a legible copy for defense. As far as we're aware, that should complete all discovery, but there has been that significant additional discovery recently disclosed. We have spoken and reached out to the next of kin and the victim. They are aware of the fact that defense counsel was appointed in April, as well as new defense counsel, and more recently. We certainly don't want to deal with any Rule 32 issues, so we do not object to this continues to give defense time to be prepared. We have, as we've indicated, already begun interviews with smaller witnesses, so we are doing what we can to start getting ready.
All right, the court finds that over Ms. Vallow's objection, she does not want to waive time, but it's necessary and in the interest of justice to waive time so that her attorneys can be prepared for trial. There is a very large amount of discovery in this case, and I said 1 terabyte. Apparently it's 6 times that. So the court will continue the final trial management conference. I'm going to set Mr. Bradley, I'll defer to you. Is a 1 hour block enough for our next setting?
Right now, I think that would cover it.
All right, let's set we'll call it a complex case management conference Friday, September 6th at 9 a.m. All right. And then we'll continue the final trial management conference from today's date to February 10 at 8:30 a.m. And let's make that 8:20 a.m. in this division. And we will continue the trial date to February 24th, Monday, February 24th. So we're waiving time between the current trial date and the new trial date of February 24. The new last day will be in today's minute entry. Is there anything else we need to discuss today from the state?
There, Your Honor.
Just briefly, Judge, I don't want to assume anything. There was a motion to be filed by the defense regarding the objection that we spoke about earlier. I just wanted to make sure that the court was okay with that.
I just did sign that order to seal in each case.
Thank you.
So it's ordered sealed. concealing the objections. All right, thank you. We'll be at recess on that matter.